Good evening, everyone, and welcome to the Humanities in Class webinar series sponsored by the National Humanities Center. Happy Election Day. I hope all of you have had a chance to vote today, and I appreciate you joining us at a time when this sort of topic and this sort of work seems ever more important to us as a country. My name is Andy Mink. I'm joining you from my home office in Chapel Hill, North Carolina. I appreciate that many of you have introduced yourselves tonight and shared where you're from, and if you haven't done that already, please find the chat box in the lower right-hand corner of the navigation panel and greet us, say hey, tell us where you're from and what you've been doing. Just down the road from me in Raleigh, North Carolina is my colleague Libby Taylor, who is ably behind the scenes making sure that tonight's webinar goes smoothly. Libby does more though than the mechanics of these sessions. She works very closely with our scholars to pull together the associated PowerPoints and materials, all of which I think are probably as valuable as anything that you'll receive from joining us tonight. So I want to thank her, as always, for her hard work and dedication in this work. The webinar tonight is going to be an audio-only webinar, but it's really going to depend on your text chat. And so while you'll hear Mike and myself, you'll hear Mike walk through his PowerPoint and share with you his expertise and his background. You'll hear me integrate questions and find ways to pull in some of the comments that you make. This really is going to be its most vibrant if your questions and your thoughts and your reflections are shared with us through that chat panel. I'll do my best to curate them and share with them as I can. Feel free to repeat them if they tend to scroll up and get lost in the shuffle. Feel free also to communicate with each other directly, but your interaction and your ability to pose those questions and respond to some of these thoughts is really going to be a big part of this. And we're also going to make sure that your mic is muted so there's no background noise in what we do. I think in some ways this is what the National Humanities Center aims to do, which is to create a space, in this case a virtual space, for experts and scholars and leading thinkers on particular topics and themes in the humanities to talk with teachers and for teachers to talk back. And I mean that in the best possible way. We want this to be a place of conversation. We want this to be a place of innovation. And the Humanities Center, both through our fellowship work that we do on an annual basis as well as our ongoing work in education initiatives, really aims to create that space where we can think through and add to good teaching and learning by understanding things better. And I would say that the content that we share, the expertise that we represent, the scholars that we introduce you to, is the value added that we bring to this kind of conversation. Inside of that, of course, is a deep belief in the pedagogy of inquiry and the pedagogy of disciplinary practice. And regardless of what you teach tonight, I hope you'll find ways to integrate this work and the material that we share, both in the teaching you do in the curriculum, but also in the conversations you have. Also in all those things that happen in a teaching classroom between the margins. That is to say, before class starts or in the hallway or at the lunch in your lunch duty, at times when kids are asking really difficult questions about the complex world we live in. And it's our belief that the more we know, the easier it is to navigate that with confidence and to share with younger students the kinds of ideas and thoughts that we'll be working through today. The Humanities Center aims to do this in a variety of ways. As many of you know, our Lessons and Resources page called American Class is deep and full of high-quality instructional materials. This is a collection that will always be growing and will be contributing to, including in other disciplines. And you can access this free resource for your classroom at any point. You can download it. You can offer it to students. And of course, these webinars, if you're hearing my voice, you've already discovered this link. I would highly encourage you to go back to our webinar page and scroll through our other offerings this year. Take a look at the kinds of topics and leaders, scholars that you'd like to meet, and go ahead and get signed up for them. As a matter of fact, next week or our next webinar just after Thanksgiving is already sold out. You'll find that we're starting to sell these out on a pretty regular basis. So if you've joined us, if you already signed up for 5 Myths About North Korea, then we're looking forward to seeing you just after the holiday break. Our next available webinar then is The Price of Liberation in World War II. We'll be working with Will Hitchcock from University of Virginia. I think that number is creeping pretty quickly and steadily towards 200, so we would love to have you go in and sign up if that's something that you'd be interested in. And we'd like you to share this link and share these opportunities with your colleagues and your faculty and your staff, so please pass it along on our behalf. We also do a lot of face-to-face work, and that includes small 1-day and 2-day workshops, and it includes longer institutes. Next summer, July of 2018, we'll be hosting a 2-week institute titled Contested Territory, America's Role in Southeast Asia. We'll really be looking at the complexities of not just the Vietnam War, but America's role in that entire region for the full 3 decades. I think oftentimes we get sort of stuck teaching, us arriving sometime in the early 1960s and then us departing sometimes in the mid-1970s without really contextualizing that experience with a deeper understanding of what happened in colonial Vietnam between the French and the Vietnamese and the roles that Americans might have played. We'll be accepting applications through March the 1st, 2018, and from that pool we'll select 36 teachers from around the country who will receive a pretty substantial stipend to come and join us in Durham for 2 weeks. So if you're interested, please follow the link both that I've provided on the screen, but also you can just go to our website and easily navigate through education programs to submit an application. And you'll find the eligibility requirements and the kinds of things that we'll be doing and the folks that you'll be working with if you check that out. We really do try to make all of our work relevant. That includes working closely with the Teachers Advisory Council, some of whom I see in the room tonight. These folks come from all across the country, and they keep us honest about making sure that what we do is relevant and applicable to the classroom. I think you'll find as the year goes on that we'll be doing a lot more with other disciplines, and we always want to make sure that our materials are able to be differentiated. If you're interested in joining this council next year, we'll be accepting applications in the spring, and I'll make sure that you get all that information both through our webinars but also through our listserv. So for tonight's webinar, it's important that you make sure that you document your participation. There will be a screen that pops up when you're finished, an email that you'll receive, and that'll invite you to do a survey. And after that survey, you will receive a certificate of joining us. Sometimes that email gets lost though because it's a mass-generated email from GoToTraining. So please double check your filters in your spam box. If your school filter is particularly rigorous, you might want to make sure that that you take a look all around. And if for some reason it just doesn't show up by the next morning, please get in touch with myself or with Libby, and we'll make sure you get what you need. So all that's sort of an orientation and an introduction to tonight. It seems like each time I introduce one of our speakers in our sessions this fall that every single day, every single week, it becomes more and more clear how important knowledge is. The currency of fact and knowledge and context just every single day seems to become increasingly important. And I'm really pleased that many of our topics have contemporary relevance. And by offering this kind of deeper insight and this deep dive into these topics, it does help you not only with what you teach, but with those conversations that we talked about earlier. In tonight's session, the Supreme Court and Civil Rights, I did schedule an election day on purpose because it strikes me that while this is not about the election process, the voting process, it does get at the heart of sort of untangling this fabric. And I'm super pleased to have Mike Klarman join us from Harvard University tonight. Mike's got a very established and long CV, and I could probably impress all of you with the work he's done and the places that he's been. In particular, I'm struck by the fact that he clerked for the Honorable Ruth Bader Ginsburg on the Supreme Court, and the work that he's done is really meant to give you an opportunity to see behind the scenes of what this deep scholarship looks like. So I'm super pleased to have Mike with us, and I'm going to now take a moment and I'm going to unmute him. It's probably the only time he would ever be voluntarily muted. Mike, if you give me just a second. There you are. Hey, Mike, are you with us? Hello, Mike.
Hi, can you hear me?
We sure can. Hey, thank you for joining us.
Sure. Thanks very much for having me.
And Mike, while you introduce your topic a little bit, I just handed you the mouse control of my screen. And again, we're super pleased to have you with us. Please take us through this topic.
Sure. Hi, everybody. I'm Mike Klarman. I teach at Harvard Law School. I mostly teach constitutional law, constitutional history, and I'm going to talk to you tonight about the Supreme Court and race. I'm going to give you a brief historical overview, and then for the most part I'm going to focus on what the Supreme Court's been doing in the race context in the last 40 years. And after I describe the relevant developments, I'm going to offer a few takeaway lessons at the end. So I want to start with the what I would call the conventional wisdom. Andy, I'm trying to move the mouse, but I'm not. There we go. Thank you very much. So the court is traditionally portrayed as a heroic defender of the rights of racial minorities, also religious minorities, occasionally other minorities as well. That conventional wisdom is stated in a 1940 decision by Justice Hugo Black, where he said that the court protected the rights of, quote, the helpless, weak, or non-conforming victims of prejudice. The idea is because the justices are unelected, because they're only remotely politically accountable, they can protect minority groups from majoritarian oppression in ways that other government institutions can't. For example, legislatures, executives who have to face the public in the polls. I want to challenge this idea that historically the Supreme Court has actually played this role. I want to suggest to the contrary that the court more often than not has actually been a foe rather than a friend to racial minorities generally and African Americans particularly. And I say this not simply to be provocative, I say this because I think it's true. I think it's surprising when people hear this, but I think basically this is an accurate statement of what the court's done in its history.
So Mike, I'm sorry to interrupt you, and I'm going to do this throughout the evening, sort of find ways to either ask questions being posed or maybe some things that come up for me. But without interrupting your flow, I have to ask. You just suggested that people would be surprised by that. Why do you think people would be surprised?
I think most people have been influenced by Brown versus Board of Education and by the Warren Court to think that the Supreme Court does play this role of protecting groups that are discriminated against at a time that political branches won't. I think Brown has become such a large part of our understanding about the Supreme Court that we forget most of the history that preceded Brown and a lot of the history that's come afterwards.
Great. And of course, for our teachers, and Brown is something that everybody in this webinar and every teacher in this country does touch on at some point. That's a pretty big thing you just said.
Yeah, Brown's a big deal, but we should keep in mind that in the last 40 years, the Supreme Court really hasn't played that role. Mostly the court in the last 40 years has been winding up the school desegregation project. The court's been striking down race-based affirmative action. The court's failed to intervene against race discrimination in the criminal justice system. And for most of the history before Brown, the Supreme Court was on the side that I think today we would say was the wrong side. The court upheld segregation. The court defended slavery. So let me start then. Before the Civil War, the Supreme Court upheld the federal fugitive slave laws against what should have been substantial constitutional challenges. So these are laws that guaranteed that slave owners whose slaves had escaped to northern states where slavery was forbidden would have a right to recapture their slaves. Congress passed a couple of statutes trying to enforce those laws, but it actually wasn't clear that Congress had any constitutional authority to adopt such legislation, and it's not clear why the procedural protections that are enumerated in the Bill of Rights shouldn't apply to northern blacks who might have been wrongfully accused of being fugitive slaves when actually they were free blacks who were being kidnapped by slave catchers. The court not only upheld the Federal Fugitive Slave Act, it also struck down northern state laws. These were called personal liberty laws, which tried to protect those northern states' free blacks from being kidnapped. The court even upheld the constitutionality of a fairly infamous provision in the 1850 Fugitive Slave Act, which actually provided that federal commissioners who were presiding over these cases, it gave them a financial incentive to find that black people who were actually fugitive slaves, the commissioners would get paid twice as much money than if they found that the person was a free black who was being wrongfully accused. The court said that was justified because there was greater paperwork involved if the commissioner actually found that the person was a fugitive slave as alleged. But this is about as obvious a violation of basic procedural due process as you could imagine, and yet the Supreme Court happily upheld the statute. Then, perhaps even more famously, in the Dred Scott case in 1857, the Supreme Court both said that Congress did not have the power to regulate slavery in federal territories, And the Supreme Court ruled that even free blacks, not just slaves, but free blacks, had no rights that white people were bound to respect. Those were probably the court's two most famous decisions involving race before the Civil War, ruling in favor of the recapture of fugitive slaves, ruling against Congress's efforts to interfere with slavery in federal territories, and decreeing that even free blacks had no rights that white people were bound to respect. Even after the Civil War, during and after Reconstruction, the court intervened repeatedly against the interests of African Americans. The court freed on what I think you can only call legal technicalities people who had lynched African Americans or perpetrated racial massacres, and the court struck down federal civil rights legislation. So the last piece of civil rights legislation passed for 80 years was the 1875 Civil Rights Act. It sought to provide African Americans equal access to public accommodations, and the Supreme Court said it was unconstitutional. Well into the 20th century, the court upheld against constitutional challenge state laws that mandated racial segregation, such as the famous Plessy versus Ferguson decision, and the Supreme Court also upheld Southern state measures that were addressed toward disenfranchising African Americans. So then move forward to Brown versus Board of Education. Brown and its immediate progeny are certainly what is mostly responsible for this kind of romantic image of the Supreme Court as a savior of the rights of racial minorities. It's true, the court's decision in 1954, which invalidated state-mandated segregation, was of enormous symbolic importance to African Americans. The Supreme Court decision was regarded by many African American newspapers as the greatest victory for blacks since the Emancipation Proclamation. By making the system of Jim Crow seem more vulnerable, Brown almost certainly raised the hopes and expectations of African Americans and helped to catalyze a movement, a transformative movement for racial change, which led to the civil rights movement of the 1960s. Yet it's still, one ought to be careful and not exaggerate the importance of the court's contribution to racial progress. It's important to note that Brown reflected social and political change as much as it caused that change. The ruling would probably not have been possible without the tremendous impetus for progressive racial change that was provided by World War II. A variety of factors connected to the war actually laid the groundwork which enabled the Supreme Court to decide Brown as it did. These included the war's anti-fascist ideology, the battlefield contributions made by African American soldiers. As many as 1 million African Americans fought for the United States during World War II, the mass migration from the rural South to the urban North of blacks, which had an important political implication, and also the so-called Cold War imperative for racial change that followed the war. That was the perception that Americans needed to do something to counteract Soviet racial propaganda, and the best way to do that was to dismantle the Jim Crow system. Now, not only did Brown reflect social change as much as it caused it, we also have to keep in mind that the court followed its broad pronouncement, its bold pronouncement in Brown versus Board of Education with a remedial decree the year after in Brown 2 that was seen as so weak and vacillating that it probably encouraged white Southerners to believe that the justices could be intimidated into backing off from the Brown decision. Then after Brown 2, what the court did was essentially vacate the field of school desegregation for the better part of a decade. Apparently what happened is the justices concluded they had nothing further constructive to do until national political opinion, the president, and Congress had rallied behind the court's decisions. But there was no such show of support anytime soon thereafter. As a result, as late as 1964, which is a full decade after the Brown decision, only 1 or 2 Southern black children in 100 attended a desegregated school. That's pretty extraordinary if you think about it. For the better part of a decade, the white South had been essentially completely successful at defying the Supreme Court's decision. As the direct action phase of the civil rights movement, the sit-in demonstrations, the freedom rides, street demonstrations such as Birmingham and Selma, as they swept the nation in the early and mid-1960s, only then did the justices begin to reassert themselves, both with regard to the school desegregation issue specifically and other issues of racial equality. In 1963, the justices warned that the desegregation context had been significantly altered from what it had been in 1954, 1955, and the justices warned that desegregation plans that 8 years earlier might have been deemed sufficient were no longer so. In 1964, the court ruled that closing public schools to avoid court-ordered desegregation was unconstitutional. That was a case from Prince Edward County, Virginia, which was one of the original cases that was consolidated into Brown. And then in 1968, in another Virginia case, the court held that the constitutionality of school desegregation plans depended on whether they produced meaningful integration, not just a formal end to segregation. So now the court was actually starting to look at results and demand that something actually happen.
So, Mike, I want to interrupt you just briefly and ask a couple of questions that have been popping up in the chat box. And I'm going to try to do these sequentially, not necessarily from the order of the questions, but from maybe what they're asking to begin with. And I'm going to sort of put you in an unfair space of speculating about something. But Katrina, who I believe is in Los Angeles, comments that, you know, wow, this is not the way that that the results of Brown were portrayed in the history books. Do you have any personal sense of why that story, this romanticization that you've mentioned, why and how that was sort of invested in? Why do we compartmentalize to that point?
I think there are a couple different reasons why that romantic vision and the celebration of Brown has become so iconic. One reason is that it's obviously a story that's very attractive to some people who have an interest in telling the history that way. So the lawyers who participated, probably lawyers in general, the legal community, judges, they like the idea of celebrating the important contribution that lawyers made to this really incredibly important 1960s civil rights movement. That explains why lawyers and law students would tell that story. That doesn't really explain why other people would accept it. I think we like to believe in founding myths because they're kind of neat. They explain things in very simple, straightforward ways. So tracing the civil rights movement and the landmark civil rights legislation to Brown, rather than a complicated story of forces that were set in motion or accelerated by World War II, such as the role of black soldiers or the mass migration of African Americans from the South to the North, or the anti-fascist ideology of the war. Those are complicated stories, and it's just easier to believe that there is kind of this founding myth. It's, you know, there are lots of analogies, but, you know, one is people who are interested in baseball will often trace the beginning of baseball back to a guy named Abner Doubleday in a field in Cooperstown, New York. And historians of the sport understand that baseball evolved gradually, and it's just simplistic, almost to the point of misleading, to suggest that it was invented at one particular time in one particular place by one particular person. Yet we're somewhat attracted to those stories. Another explanation is, I think liberals and conservatives today both kind of have incentives to celebrate Brown, but it's for very different reasons. Political liberals like Brown because it stands for the proposition that we ought to try to move toward an integrated society, that the Jim Crow system was bad, theories of racial supremacy are reprehensible, and we should repudiate them and try to remedy the history of race discrimination. Political conservatives like to interpret Brown as standing for a principle of colorblindness, a principle that it's true we have a history of white supremacy and hierarchy, and that should be repudiated, but the way to move beyond that is for the government to stop seeing race as a relevant category, and that's what leads to efforts by conservatives, for example, to constitutionally ban race-based affirmative action, or to strike down efforts by school boards to try to promote integration through race-conscious means. So you actually see that with the liberals and conservatives on the Supreme Court. They actually all agree that Brown versus Board of Education was an important decision, but they interpret it in very different ways. And I think because liberals and conservatives have been able to marshal their own interpretations of Brown, that provides additional incentive to celebrate Brown because they all agree about it. You're not going to see a similar sort of celebration of Roe versus Wade because abortion rights are still very controversial, and therefore, you know, half the country sees Roe as a great decision and half sees it as a terrible decision, but everybody can agree about Brown, though for different reasons.
I don't know if you could hear, if you just paused briefly and put your ear out your window, you'd hear heads exploding all over the country over what you just shared with our group. Because again, you know, I think in our teaching, our curriculum, and sort of the way we portray that, we do in education perpetuate exactly the myth that you just described, and it's really interesting to have that punctured so effortlessly in a way. I've got one more question for you before we move on. This is from Jamie Lathan, who's in Durham, just down the road, and in fact, one of our Teachers Advisory Council members here at the center. And without going too far astray of tonight's topic, I wonder if you have any comments on Native American rights and the parallel with Worcester versus Georgia.
Right. So the Supreme Court occasionally has done a little better on the rights of Native Americans, well, not always. The court did stand up. So Worcester versus Georgia is an 1832 decision where the Supreme Court said that the state of Georgia, which was asserting its sovereignty over the land of Cherokee Indians, sovereignty that had been protected by a federal treaty, the Supreme Court said Georgia doesn't get to do that. That federal treaties negotiated between the Cherokee back in the 1790s and the federal government had given the Cherokee the right to exercise political sovereignty over their own land, and that the Cherokee had no authority under the Federal Supremacy Clause, which makes federal treaties supreme against state laws, that the Cherokee had no right to, that Georgia had no right to assert its sovereignty over the Cherokee. So that was a bold decision. When the Supreme Court issued it, they knew, the justices knew, that Georgia would defy the decision, and they had no reason to believe that President Jackson would actually back up the court. But the bottom line is the decision didn't do the Cherokee much good. Cherokee removal was something that Andrew Jackson was deeply committed to. Congress passed removal legislation, and the Cherokee were gone from Georgia within a decade. That's actually an illustration of the point that even when the Supreme Court does occasionally stand up for the rights of persecuted minorities, at the end of the day, those rights aren't necessarily fully vindicated. So the point is, court decisions without public opinion backing them up aren't necessarily going to mean very much. And that's kind of the case of Brown in the South for the first decade, until Congress passed civil rights legislation that threatened to withhold funding from school districts that declined to enforce Brown. Brown was systematically violated in the South. So sometimes the court intervened on behalf of the rights of Native Americans, but at the end of the day, the political branches of the national government simply went ahead with their mission of moving all the Indian tribes west of the Mississippi River and basically violating the treaty rights that they had been granted, and the Supreme Court was powerless to do anything about that. So I'm sorry, go ahead, Andy.
You said thank you. Thank you for answering those questions.
Sure, my pleasure. The more questions, the better. So moving on to the mid-1960s, I mentioned the point about how the Supreme Court started to get involved again in school desegregation cases. The court also got involved in some other issues with regard to race, and initially those decisions were quite favorable. So the court intervened in a bunch of cases to overturn criminal convictions of sit-in demonstrators. The court actually creatively invented some new constitutional law to protect the NAACP from being legally harassed by southern states. The court expanded the range of private actors who are subject to the 14th Amendment The 14th Amendment only by its terms binds states, yet the Supreme Court managed to expand it to cover some private actors and prevent them from engaging in race discrimination. And the court upheld some bold exercises of congressional power on behalf of civil rights. The court said the 1964 Civil Rights Act, the 1965 Voting Rights Act, the 1968 Fair Housing Act. The court managed to find congressional power to justify all of those statutes. The Warren Court justices also revolutionized criminal procedure, and that was an area that disproportionately affected members of racial minority groups. And the court transformed a kind of abstruse body of law called the law of federal courts in an effort to prevent southern states from nullifying the constitutional rights of civil rights protesters. So during this decade or decade and a half, from roughly 1954 to 1968, 1969, the court actually did a pretty good job of realizing or actualizing this image of the Supreme Court as a heroic defender of the rights of racial minorities. But then, just as the civil rights movement had reached its peak and the Supreme Court had reached its zenith of protecting the rights of racial minorities, social and political conditions began to change, disrupting civil rights progress. Opinion polls had showed that civil rights were the foremost issue on the nation's political agenda from the summer of 1963, that's right after the Birmingham demonstrations, through the spring of 1965. But at that point, the war in Vietnam started to displace civil rights from its peak of prominence. Less than 6 weeks after President Lyndon Johnson signed the landmark Voting Rights Act into law in the summer of 1965, a devastating race riot swept through the Watts neighborhood of Los Angeles, killing nearly 35 people. And of course, that proved to be the harbinger of dozens of other race riots in the late 1960s. In addition, by the mid to late 1960s, black nationalism, which often eschewed racial integration as a goal and nonviolence as a tactic, was beginning to sow deep divisions within the civil rights organizations and also souring many white Americans on the cause of racial reform. You can already start to see the racial backlash materializing in national politics. In 1964, the Republican Party nominated for president Senator Barry Goldwater, whose the main thing people knew about him that year was that he was a vocal opponent of the 1964 Civil Rights Act. Goldwater's nomination accelerated a national political realignment. 5 Deep South states voted Republican for the first time in 100 years, while African Americans deserted the party of Lincoln in droves. In 1960, about a third of African Americans had voted for Richard Nixon, the Republican nominee, but in 1964, 90% of African Americans voted against Barry Goldwater, voting for Lyndon Johnson. By 1966, a racial backlash among whites was already beginning to appear evident in the North as a combination of urban race riots, proposals for fair housing legislation, and growing African American demands for economic empowerment were starting to tear asunder the civil rights coalition. Democrats lost 47 seats to Republicans in that year's congressional elections. That's 1966. In 1968, Republican candidate Richard Nixon won the presidency on a platform emphasizing domestically law and order, a relaxed pace for school desegregation in the South, and opposition to busing to accomplish desegregation. 97% of African Americans voted for the Democrat Hubert Humphrey that year, but only 35% of whites did. And as you may know, Nixon narrowly won both the Electoral College and the popular vote. The 14% of voters who supported the third-party bid of the openly racist George Wallace provided a temptation for the Republican Party in the future to move even further to the right on race issues in order to court those Wallace voters. Nixon's victory at the polls that year translated directly into changes in the racial jurisprudence of the Supreme Court. He appointed 4 new justices during his first term in office. Nixon's appointees quickly transformed the racial jurisprudence of the Supreme Court. In 1974, 25 years after Brown, the court decided its most important school desegregation case since Brown. In Milliken versus Bradley, a case from Detroit and its suburbs, the justices ruled by 5-4 that white suburbs, largely white suburbs, could be included in a federal court's desegregation decree only if there was proof that school district lines had been racially gerrymandered. And that's difficult to prove. As a result, federal courts were disabled from accomplishing meaningful school desegregation in most cities from which white residents had recently begun flocking to the suburbs. That was a 5-4 decision. Nixon had appointed 4 of the 5 justices in the majority, and the basic outcome was that Detroit, one of the first majority black cities in the country, which quickly became 70–80% black, Detroit could not be roped into a desegregation decree with the surrounding suburban districts, which were 99% white.
Mike, let me ask you this question, and it's looking at it the way we are tonight. A century plus of kind of trends and sort of the larger pushes and pulls of what's happening. Just in your opinion, in this conversation, how aware are the political machines and candidates and elected officials in the moment of these kinds of things?
How aware are they of what?
Of the role that the Supreme Court does or does not play, or the reality of the implementation of these things, and as you're kind of portraying it, how aware do you feel that those elected officials are of the power of what you're describing?
They're very aware of it. So Goldwater in 1964 was trying to turn the court into a law and order issue. He was running against a recent criminal procedure decision which had allowed a defendant to go free based on the fact that he had confessed after being denied the opportunity to see his lawyer in the police house. Nixon did that even more in 1968. So Nixon is running explicitly against the Supreme Court decision in Miranda, which he said had unleashed criminals freeing murderers and rapists, and he's running against Supreme Court decisions on the school desegregation issue. It's a quite consciously Southern strategy where Nixon is trying to persuade white Southerners who traditionally had been Democratic voters, largely because of the Civil War and the fact that the Republican Party was the party of Lincoln and the party of emancipation and the party of Reconstruction. Nixon is saying to these Southern whites, you should be with the Republican Party on race. We just nominated Barry Goldwater. He opposed the Civil Rights Act. I'm not willing to oppose the Civil Rights Act, but I'm Richard Nixon, and I promise you I'm going to put people on the Supreme Court who are going to start to respect police officers and not let murderers and rapists go free on the street, and I'm going to appoint justices who are going to start to cut back on school desegregation. So Nixon is explicitly running on the issue of the Supreme Court and race, and I think for the rest of the history, all the way up to the present, the Supreme Court's often been a big issue, whether it's abortion, whether it's affirmative action, whether it's executive power issues such as what goes on in Guantanamo. Politicians are aware of what the Supreme Court does. In 2004, gay marriage was a big issue. The Supreme Court hadn't decided the case yet, but the Massachusetts Supreme Court had, and George W. Bush, I don't know if people remember this very well, but the gay marriage issue was a huge issue in 2004, with John Kerry saying, I support civil unions, I don't support gay marriage, but I also don't support the Republican-sponsored constitutional amendment to bar gay marriage. And George Bush saying, well, I don't understand, if you oppose gay marriage, why don't you support this constitutional amendment? And it was a huge deal in the election, and there's actually a respectable argument that George Bush was only reelected because of the gay marriage issue. If he had not won Ohio, John Kerry would actually have been elected president, and Bush only won Ohio by 2 percentage points, and there was a gay marriage ban on the ballot that year in Ohio, and they banned gay marriage by 62 to 38%. So gay marriage lost by 24 points, Bush won by 2 points. It's not hard to make out the case that that was the issue that pushed Bush over the top in Ohio. So yeah, the politicians are very much aware of how the Supreme Court is impacting the public psyche, and they're trying to manipulate the issue to advantage themselves.
Thank you.
So to continue with what the Nixon appointees were doing, Washington versus Davis, which is not a decision that I think is famous to a lot of non-lawyers. This is an incredibly important equal protection decision in 1976. And what it says is, if there's a law that on its face says nothing about race, so the actual issue there was a test to become a police officer, and it's an aptitude test. It says nothing about, you know, whites being preferred or blacks being dispreferred. Everybody takes the same aptitude test. But it turns out that that test produces an impact which is strongly correlated with race. So African Americans were 4 times as likely to flunk the test as whites, probably because of a long history of discrimination and underfunding of black schools in the District of Columbia. And the critically important equal protection question is it enough to show that the law has a disparate racial impact, or do you have to show it was illicitly motivated, that you were trying to discriminate against African Americans? And the conservative-dominated court said you have to show that there was a discriminatory animus. It's not enough simply to show a disparate racial impact. So as a result of this, and this may be eye-opening because probably all of you have heard about the issue I'm going to mention, but maybe worried why this law wasn't obviously unconstitutional, federal sentencing guidelines since the 1980s have provided the same punishment if you possess 5 grams of crack cocaine as if you possess 500 grams of powder cocaine. Now, it turns out 90% of the crack defendants are black and 3/4 of the powder defendants are white. Why is that not obviously unconstitutional for this severely disparate impact that you're imposing on the mostly black crack possessors as opposed to the mostly white powder possessors? And the answer is the Washington versus Davis rule. It's not enough to show a severe disparate impact. You need to show racial motivation. Then moving, and if you're interested, actually, that's the argument against the Muslim travel ban. That's why courts have been striking it down, is because racial motivation, whether it's racial motivation or religious motivation, is everything with regard to both the 14th Amendment Equal Protection Clause and the First Amendment Free Exercise Clause. And Trump, during the campaign, said over and over again that he wanted a ban on Muslims, and that's relevant evidence of his motive, and that's why courts have been holding his words against him. They're not making up some new rule. That's actually well-established, both First Amendment doctrine and equal protection doctrine for the last 40 years. Then moving on to the Bakke case, this is another example, another 5-4 decision where everything turns on the fact that the Nixon appointees were fairly conservative in their racial jurisprudence. So now the court rules narrowly that race-based affirmative action is subject to the same strict judicial scrutiny as had been applied to traditional white supremacist Jim Crow legislation, like the law that was struck down in Brown. Conservative justices then and ever since have read the 14th Amendment, which of course was adopted in order to protect the newly freed slaves from race discrimination with regard to basic civil rights, as a mandate of colorblindness. The court's overall record on race-based affirmative action has been decidedly mixed since Bakke. The conservative justices have almost invariably voted to strike down such programs, while the liberal justices have almost always voted to uphold those programs. Individual case outcomes have been determined by the votes of swing justices. First Lewis Powell in the 70s and 80s, then Sandra Day O'Connor in the early 2000s, and today Justice Anthony Kennedy. But it's fair to say the court has invalidated at least as many affirmative action programs as it has sustained. The conservative justices' hostility to affirmative action, I want to suggest to you, reflects a constitutional double standard. These are the same justices who ordinarily, for example, if it was a case involving gay marriage or a case involving abortion regulations, they would profess a commitment to judicial restraint, deference to democratic decision-making, respect for states' rights, and a commitment to an interpretive methodology limited to the text of the Constitution and the original understanding of the text. Yet all of those factors I just noted, respect for democratic decision-making, commitment to judicial restraint, respect for states' rights, commitment to a limited methodology of textualism and originalism, all of those point in the direction of allowing race-based affirmative action. To strike down affirmative action, for example, when adopted by the University of Michigan, is for unelected judges to invalidate the policy preferences of state and local governments on a fairly thin constitutional basis. The text of the 14th Amendment actually says nothing about government color blindness, and the original understanding of the 14th Amendment was plainly not a commitment to color blindness. The framers of the 14th Amendment and their constituents, somewhat ironically, were actually too racist to require that government abandon all racial classifications. They thought that laws disenfranchising blacks, excluding African Americans from jury service, segregating them in schools, and even forbidding interracial marriage, they actually thought all those laws would be permitted under the 14th Amendment. The only thing they thought they were forbidding was race discrimination with regard to certain civil rights that distinguish free blacks from slaves. So things like the right to contract, the right to own property, the right to sue in court to protect your other rights. You can't fairly derive a mandate of color blindness from the original understanding of the 14th Amendment.
And that might actually be an interesting place for me to insert a question from the audience, Mike.
Great.
You know, these are complex topics, and we have some passionate questions, and I want to make sure that I get this right from Andrew Saldina. So I'm actually going to take a moment to read it. It's a little bit longer, but it seems like it might fit into where you just finished. And Andrew says, and I'm reading his question directly, isn't the basic thesis of this presentation that the Supreme Court should insist on a certain kind of legislation that happens to align exactly with a progressive agenda? For instance, there are strong arguments that can be made that colorblindness is exactly the right policy to fully promote equality in our country, yet it sounds like Dr. Klarman, Mike, would argue that it's self-evident that such a decision would count as the court being a foe to minority empowerment. In other words, and here's the question for you, how would you respond to the criticism that this presentation of the issue reveals a strong liberal bias?
So it's a terrific question. I want to respond in two different ways. When I say that the Supreme Court in the last 40 years has been a foe to the interests of African Americans, I'm defining the interests of African Americans as a majority of African Americans would define them. So if you take the position, for example, of Justice Thomas, that race-based affirmative action is a bad thing for racial minorities, then it's certainly fair to say the Supreme Court, by striking down affirmative action, has been siding with the interests of African Americans. Most African Americans think that Justice Thomas is wrong, and when you strike down race-based affirmative action, or you refuse to strike down race discrimination in the administration of the death penalty, or when you strike down minority voting districts that were carved in such a way as to enhance minority representation, most African Americans would say those are bad decisions from the perspective of our interests. So it's a very good question, but I'm simply defining foe or friend as most African Americans would identify the Supreme Court. Now, on the question of whether I'm saying the Supreme Court should advance a progressive agenda, I'm actually not taking that position. I think most of us would agree that when the court overturned the convictions of lynchers or upheld segregation or struck down laws trying to constrain the spread of slavery, I think most of us would agree that there the court was doing something that, from our perspective today, the court obviously was on the wrong side. Brown versus Board of Education, I'm willing to defend as a good decision, but I'm not defending it on the ground that the Supreme Court was following the original understanding of the 14th Amendment. I actually think that the 14th Amendment was not intended to strike down school segregation. I think the only way you can defend Brown is to say that school segregation is wrong, it's immoral, and we're willing to trust justices to depart from the original understanding of the 14th Amendment. What I want to insist on, though, this is really critical to my point, when conservative justices say we need to strike down school segregation because of color blindness, they are reading into the Constitution a principle that is actually not there in the text and is not there in the original understanding. That's the exact same thing they would denounce liberal justices for doing when they say there's a right to gay marriage or there's a right to abortion. They would say that's making up rights that are not in the Constitution, that's refusing to defer to democratic legislatures, refusing to respect states' rights, engaging in judicial activism. And I'm pretty sure they're doing exactly the same thing when they strike down race-based affirmative action. So I'm not trying to read a progressive agenda into the Constitution. I'm trying to describe what the Supreme Court done over the course of history. And I would say this is one of the lessons, the takeaway points that I'm going to get to. I would say the Supreme Court partly reflects the era in which it operates, but it also partially reflects the ideology of the judges who sit on the court. I'm not saying whether that's a good thing or a bad thing. I'm simply describing how the court operates, and I'm saying that in the last 45 years, the Supreme Court, from the perspective of racial minorities who are affected by affirmative action, and it's not all racial minorities, so Latinos and African Americans often have a different view about affirmative action than Asian Americans, not always, but often. I'm simply saying that from the perspective of African Americans who in opinion polls would tell you that race-based affirmative action is a good policy, the Supreme Court has not been their friend for the last 45 years. So I talked about school desegregation. I'm moving on now to the Rehnquist Court. Chief Justice Rehnquist assumed the chief justiceship in 1986, and we call it the Rehnquist Court. And what that court did is it began to wind up school desegregation. Between Ronald Reagan and George W. Bush, there were 5 new justices appointed between 1981 and 1991. Those were always conservative justices, not surprisingly, because these were conservative presidents. And from that point forward, the conservatives had a fairly secure majority on the Supreme Court on race issues. It turns out, interestingly, not on other issues, because often Justice Kennedy has turned out to be a swing vote, and sometimes O'Connor did on issues involving abortion or gay rights, or some issues involving the death penalty, but not on race issues. There was a conservative majority from the late 1980s going forward. By 1991, the last 10 appointments to the Supreme Court had been made by Republican presidents, none of whom won more than 10% of the black vote at the polls. It was the Rehnquist-led conservatives who sounded the death knell for court-ordered school desegregation. In a case from Oklahoma City in 1991, a narrowly divided Supreme Court ruled that once a school board had complied in good faith for a reasonable period of time with a desegregation order, and the vestiges of past discrimination have been eliminated to the extent practicable, at that point the school district was entitled to be released from federal supervision. If terminating the desegregation decree under those conditions resulted in increased school segregation, which it almost always did, then the justices said it was private housing preferences that were probably the cause, and responsibility could no longer be ascribed to the government. In 1995, the conservative justices, again in a 5-4 decision, indicated that their tolerance for remedial alternatives to busing had also run thin. In a 5-4 decision from Kansas City, Missouri, the court forbade the use of magnet school programs for the purpose of enticing suburban whites into racially integrated urban schools and imposed virtually insurmountable hurdles to judicially mandated increases in educational funding as a remedy for school desegregation. So now not only could you not pursue busing as a remedy, you also couldn't pursue increased funding as a remedy for past segregation. In addition to curbing court-ordered school desegregation and race-based affirmative action, the Rehnquist Court's conservative majority inaugurated a new strand of constitutional jurisprudence that called into question the permissibility of legislative districts that were gerrymandered to enhance the prospects of minority racial groups who are trying to elect representatives of their own race. In a series of 5-4 decisions, the court ruled that the 14th Amendment presumptively bars such districts when the predominant motive behind their creation was racial. As with the conservative justices' posture toward affirmative action, these decisions are difficult to reconcile with the original understanding of the 14th Amendment, which plainly did not protect political rights such as voting. That's why they needed a 15th Amendment adopted after the 14th Amendment. Perhaps most disturbingly, the Rehnquist Court actually proved pretty indifferent to race discrimination in the criminal justice system. In McCleskey versus Kemp, the conservative justices, and again, this is a 5-4 decision dividing the court ideologically, the conservative justices rejected an equal protection challenge to the discriminatory administration of the death penalty in Georgia. Specifically, there was a study that the justices stipulated to be valid for purposes of this litigation, showing that defendants who murdered whites were 4.3 times more likely to receive the death penalty than were those defendants who murdered blacks. Essentially, what Georgia was doing, if you believe the death penalty is a deterrent, Georgia was devaluing the lives of black citizens by refusing to administer the death penalty as aggressively toward those people who killed blacks as it did toward those who killed whites. The court rejected the challenge, observing that race discrimination could not possibly be entirely eliminated from the administration of the death penalty as long as actors integral to the system, such as prosecutors and jurors, continued to exercise significant discretion. The majority also noted that similar racial disparities probably existed throughout the criminal justice system, which meant that vindicating this defendant's claim would have potentially enormous consequences. One can be pardoned for wondering why that observation did not make McCleskey's claim more compelling rather than less compelling. Lastly, and let me mention this other criminal procedure case, and then, Andy, if there are more questions, it'd be a good point to take them. Okay. In United States versus Armstrong in 1996, the court imposed a virtually insurmountable hurdle for defendants who alleged racially selective prosecution. Before black defendants could gain discovery, meaning access to the prosecutor's files, in order to back up claims of racially selective prosecution, according to the court, they had to demonstrate that similarly situated white defendants had not been prosecuted. But that was the very point on which the black defendant was seeking discovery. This is a catch-22. We're not going to give you the evidence to prove race discrimination until you prove race discrimination. The fact that in the previous year, this particular U.S. Attorney's Office had prosecuted 24 African Americans and not a single white for crack distribution, according to the court, did not establish the prima facie case of selective prosecution that's necessary in order to justify an order for discovery, which would then enable you to try to prove selective race discrimination in prosecution. Got a question for me, Andy?
Okay, well, first of all, I'm going to give you a chance to just kind of stop and have a glass of water.
Yeah.
But yeah, as a matter of fact, I do, and this is from Tori Hester. I'm going to sort of read this on the fly. It says, Tori writes that she's been reading in terms of the Fourth Amendment, whites have been protected by and large by the Fourth, while African Americans have not been protected in similar ways. Can you speak to Fourth Amendment cases?
Um, there's been a lot of scholarship in recent years arguing that the kind of privacy that the justices tend to privilege is the kind of privacy that more affluent, suburban, wealthier white people tend to enjoy, rather than the kind of privacy that would be more important to relatively less affluent urban minorities. So I give you some examples. People are protected in the privacy of their home or the privacy of their car, but if you're the sort of person who travels on buses, which tends disproportionately to be poorer, often on the East Coast it tends to be African Americans, the court has been fairly lenient towards police officers going onto a Greyhound bus, telling everybody there, we'd like to search your possessions, and not bother informing them that they have the right to say no. Similarly, the Supreme Court has been, if you think about the way drug transactions tend to happen in relatively affluent suburban neighborhoods, it's much more likely to be within the privacy of a home where you're protected by the Fourth Amendment. Police are much more likely to go after drug dealers who are dealing drugs in open-air drug markets in cities where it's much more likely to be drug dealers who are members of racial minorities. We incarcerate people based on marijuana possession, and even though marijuana possession is one of those drugs where whites and blacks actually use the drug in relatively equal numbers, you're somewhere between 4 and 7 times more likely to go to jail as a black marijuana user than a white marijuana user. And that's partly because of this Fourth Amendment privacy right, that it's a lot easier for police officers to arrest and prosecute drug dealers and drug users who are in public than those who are in the privacy of their own home in suburban affluent neighborhood. So yes, the answer is not necessarily for transparently, openly racial reasons, but because of correlations between race and poverty, because of the fact that it's going to be a lot easier to intervene where people don't have privacy rights, people who spend their lives in public, who might be homeless. It's going to be a lot easier for the police, just because of the way the Fourth Amendment is constructed, to go after those people. Yes, there's a big disparity in the way that the Fourth Amendment ends up affecting the privacy rights of people. And simply because people who are more affluent and can afford lawyers are less likely to waive their rights, more likely to know their rights, more likely to be in a position to insist on their rights, any sort of disparities that exist with regard to race are likely to reproduce themselves with regard to race because of the strong correlations between race and poverty in our society. It's true today that African Americans, on average, control less than 10% of the wealth of white families. And given that, they're just much less likely to be able to hire well-educated, talented lawyers to defend themselves. They're less likely to know their rights. The average person traveling on a Greyhound bus is less likely to know that they actually have the right when police officers climb on board the bus and say, we'd like to search your possessions. They're less likely to know they have the right to say, no, I don't agree to that. So yes, racial differences are reproduced with regard to the Fourth Amendment as well.
Thank you.
Sure. Moving on then, moving on to the last decade. In 2010, another slim conservative majority, and again, this is not my interpretation. Anybody who teaches con law, who reads the cases, would tell you there are closely divided courts where ideological divisions are reproduced in the majorities. So this is another slender 5-4 majority. The court brought the court's racial jurisprudence full circle from Brown. So this is the parents involved case. In 1954, of course, the court had ruled that state-mandated racial segregation in schools violated the 14th Amendment. Now in 2007, the conservative majority, in an opinion by the newly elevated Chief Justice John Roberts, ruled that for school districts to take race of students into account in order to promote integration, not segregation, integration, also violated the 14th Amendment. The conservative majority in this case spoke of the constitutional mandate of colorblindness without offering any textual or historical support for the idea that colorblindness is constitutionally required. And as I just suggested a few minutes ago, I don't think there is textual or historical support for that idea. Indeed, the conservative justices relied heavily on Brown and, somewhat surprisingly, on the NAACP's argument to the court in Brown, which is a pretty unusual source of constitutional interpretation. Brown, of course, does not have to be read to forbid all government racial classifications. It's easy enough to read Brown to forbid only those racial classifications adopted for the purpose or having the effect of disadvantaging traditionally oppressed racial minorities. It's true the NAACP had argued in Brown for a constitutional mandate of colorblindness, but that's not what the Supreme Court gave the NAACP. The conservative justices and parents involved were taking the NAACP's Brown argument badly out of context. The NAACP had argued for colorblindness during an era of formalized Jim Crow. To portray the NAACP as repudiating race-conscious government measures designed to remedy past discrimination at a time that nobody could have dreamed of legislatures voluntarily adopting those measures, I think smacks of disingenuousness. Then 6 years later, in Holder versus Shelby County, the court struck down the preclearance provision of the Historic Voting Rights Act, which had required Southern jurisdiction to pre-clear changes to their voting rules with the Justice Department because those states had an egregious history of race discrimination in voting. For example, in Mississippi in 1965, only 6% of African Americans were registered to vote as compared with 60% of whites. Declaring that, quote, history did not end in 1965, the conservative majority, and again this divides the court 5-4, ruled that race discrimination in the Southern political process was largely a thing of the past, even though fewer than 10% of whites in Mississippi and Alabama voted for President Obama, and Republican-controlled legislatures in dozens of states over the last decade have enacted thinly veiled voter suppression mechanisms to make it harder for racial minorities and poor people to vote. So that's the history. I thought I would draw 3 lessons. This would just take me a couple minutes, and then I'm happy to spend the rest of the time answering questions. So here are 3 lessons I would take from the last 40 years of the court's racial jurisprudence. First, most of these decisions were, as I've repeatedly emphasized, 5-4. Had there been one more liberal justice, for example, had Senate Majority Leader Mitch McConnell not successfully stolen the Supreme Court seat that rightfully belonged to Judge Merrick Garland, many of these decisions likely would have been decided differently, or they would be overruled by today's Supreme Court. It's not predestined that the court would reject race-based affirmative action, prematurely terminate the school desegregation project, or reject the argument that the Constitution bars racially disparate impacts regardless of racially discriminatory motive. Constitutional interpretation involves judicial discretion. Judicial discretion reflects political ideology, and conservative justices tend, not surprisingly, to subscribe to the conservative racial ideology of the party that appointed them. That, just as liberal judges reflect the liberal ideology of the party that appointed them. The conservative ideology of these justices, who've been a majority for the last 45 years, embraces a narrow, formalistic conception of what counts as race discrimination, deliberate discrimination, but not unintended, unconscious race decisions that impact minorities differently, an ideology that abhors the use of racial preferences, whether benignly motivated or not, and denies this country's ugly history of white supremacy, treats it, not denies it, but deems it more worthy of repudiation than of remedying. Second lesson, while the political composition of the court is partly fortuitous, The victories of the conservative bloc of justice since 1970s have predominantly been a function not of fortuity but of politics. Between 1968 and 2008, Republicans controlled the president for 28 of those 40 years, Democrats only for 12. Of the 14 appointments made to the court between 1969 and 2006, 12 were made, 12 of 14, by Republican presidents, most of whom prided themselves on their conservative politics. Because constitutional interpretation is so inextricably fused with politics, it's not surprising that justices appointed by presidents for whom very few African Americans voted would decide race-inflected cases in ways that contravene the preferences of the majority of African Americans. Third and finally, I think one has to wonder how much difference it would have made had the liberal justices triumphed in some of these race cases that I've been describing. Public opposition to busing the suburbs was so intense by the early 1970s. Think, for example, the anti-busing riots in Boston, of all places, in 1974. Boston, supposedly the cradle of abolitionism, with school desegregation riots in 1974. Public opinion was so hostile to busing that a contrary decision in Milliken, that's the 1974 decision that refused to bus the suburbs, that if the court had come out the other way in Milliken, it might have spawned a constitutional amendment to overturn the court, or it might have led to the courts overturning the decision because of massive defiance. In addition, a conservative majority of justices, even when they haven't succeeded in striking down affirmative action, for example, when the liberals won on affirmative action in the Michigan case in 2003, a public opinion has become so hostile to affirmative action that that result was overturned at the polls, just as it has been in California, Washington, Nebraska, Michigan. Most Americans, when they vote on race-based affirmative action, actually now vote against it, although most African and Latinos vote in favor. Similarly, last example, by the time the court in 2007 invalidated race-based pupil assignment policies in grade schools, policies that were designed to promote integration, by that point in time, only 5 to 10% of all school districts employed such policies. Most of the country had already given up on voluntary policies to promote integration. So to sum up very quickly, while the last 40 years of conservative hegemony on the court has yielded racially regressive results pretty much across the board, and again, that's from the perspective of a certain view about which policies favor the interests of racial minorities, one should not absolve the larger society that the court serves of responsibility for those decisions. The Supreme Court mirrors society at least as much as it shapes it. Conservative justices could not have foisted a regressive racial jurisprudence on the American people without their acquiescence. And as I think has been brought to the surface since Trump's election to the presidency, we've made a good deal less racial progress in the last generation than most of us would have assumed. So happy to take questions on any of those issues we've been talking about.
Thank you, Mike, and I do appreciate you working through so many complex questions and points succinctly and in a very provocative way. And I think a lot of the chat conversation is reflective of that. And again, I think what we try to do at the Humanities Center is create this space for this kind of conversation and debate and discussion. So I do have a specific question from one of our participants, but I'm actually going to start with something that's maybe a little less specific, and that's by asking you, as a teacher, as an educator, as an historian, you've got some of the best law students in the world at Harvard. When you share this kind of work and you share something similar to what you've done tonight, what's some of the pushback that you get? How do your students respond to the points that you're making?
So I don't get a lot of pushback if I'm talking about the early history, if I'm talking about how the Supreme Court in Dred Scott or Prigg versus Pennsylvania in the 19th century opposed the interests of racial minorities. It's a little bit hard for anybody to argue with that. I don't think I get much pushback on the idea that Brown is mostly a reflection of social and political forces that grew out of World War II. I think most of them are prepared to accept the idea that the justices in Brown were reading their own progressive racial views into the Constitution, that they were horrified in the wake of the Nazi Holocaust of policies like racial segregation, which the justices saw as very similar to the way Hitler treated Jews. Not much pushback on that. I think the pushback you get is what you would expect, which is to criticize the conservative justices for being inconsistent when they strike down race-based affirmative action. But I actually think that most of the conservative students at Harvard are pretty open-minded, and whereas I'm not going to convince them one way or the other as to whether race-based affirmative action is a good policy, if they're conservative, they tend to think that it's better to have colorblindness, that the best way to get away from race is have the government simply cease taking race into account. I think most of them are prepared to accept my critique that when conservative justices read colorblindness into the Constitution, they're essentially taking a policy preference that's not fairly located in the text or original understanding, and they're turning it into a constitutional command. And that's really not very different from what they criticize liberal justices from doing when they say there's a constitutional right to same-sex marriage or a constitutional right against abortion restrictions. So the one thing that I don't think a law school education is likely to do is change anybody's mind on the underlying policy dispute. I'm not trying to change people's minds on abortion or whether gay marriage is good policy or whether race-based affirmative action is good policy. What I'm trying to get them to think hard about is whether justices across issues are consistent in the principles that they invoke. So, for example, if a conservative Republican today says we ought to defer to the states, and that's why I like healthcare repeal, because it's going to return money to the states in the form of block grant. But if that same person says, well, I think the federal government ought to pass legislation preventing the states from making gun manufacturers liable for gun violence perpetrated by gun owners, there's a lot of tension in those positions. If you favor some issues being returned to the states, but on an issue where you don't like what the states are doing, you'd rather have the federal government, it's important to see whether you actually are committed to states' rights or whether you're just manipulating that concept to support particular policy positions. And that actually, I think, infects judicial reasoning as well, and that's mainly what I'm trying to convince my students of. And there, I think they're actually pretty open-minded about that.
Excellent, thank you. I do have a question that directly asks about this myth of colorblind, myth of the colorblind. Jimmy asked, does this myth come from, I'm sorry, just one second because it scrolled up on me just as I was about to read it to you. Does the myth of a colorblind constitution come from Justice Harlan's dissent in Plessy?
So very good question. Justice Harlan in Plessy talked about a colorblind constitution, and that's certainly a position that Justice Scalia, Justice Thomas, Justice Alito would like to celebrate. But it's important to note a couple things. First of all, Justice Harlan lost. He's the only dissenter in that case. So the majority rejected the idea of colorblindness, and that's what the Supreme Court did for most of our history. It's also important to note that even Justice Harlan, who dissented, would have distinguished between railroad segregation, which is what was the issue in Plessy, and school segregation. We know from Justice Harlan's other writings that he would have been fine with state-mandated segregation of public education. So even Justice Harlan was not committed to colorblindness in the way that the language of his dissenting opinion might lead you to believe, and the evidence that the people who wrote the 14th Amendment were not committed to colorblindness is all over the legislative history. So Republicans, the ones who were supporting the 14th Amendment, say over and over, this will not require that you desegregate your schools, this will not even require that you allow black people to vote. That's why the 15th Amendment was necessary a couple years later. So the myth, it's obviously an attractive myth. If you're conservative politically and you don't like race-based affirmative action, it's an attractive position to say the Constitution doesn't allow it. Just like it's an attractive position if you're conservative and you believe in an individual right to keep and bear arms, to say that the Second Amendment defends that position. But if you're conservative and you don't like gay marriage, you say gay marriage is invented. There's nothing in the Equal Protection Clause about gay marriage. The problem is the original understanding of the Second Amendment also had nothing to do with an individual right to keep and bear arms, just like the 14th Amendment original understanding had nothing to say about race-based affirmative action and colorblindness. So the point is, and this is not the sort of thing you hear if you read the newspapers, but I'm pretty sure this point is right, and I think you can actually demonstrate it if you just go through the issues one by one. Conservative justices don't like it when liberals make up, from their perspective, rights to abortion, rights against the death penalty, rights to gay marriage, but the conservative justices do exactly the same thing on a different set of issues. So they say campaign finance regulations violate the First Amendment, and they say gun control violates the Second Amendment, and they say race-based affirmative action violates the 14th Amendment, but the text and the original understanding of none of those provisions leads to those outcomes. They're engaging in the same sort of activism. They're refusing to respect democratic legislatures. They're refusing to defer to the states on those same issues, well, on different issues, in the same way that they accuse the liberal justices of doing on different issues. So what we have is activism across the board, and the conservatives like to pretend that they're not being activists and to denounce the liberal activism. And that's the misconception. When President Trump denounced liberal activists, he doesn't think it's activism to say that the Second Amendment doesn't allow gun control, but it is activism. If you go back 50 years, nobody thought the Second Amendment meant an individual right to keep and bear arms.
That leads me to Trevor's question, Mike, which is to ask, in your opinion, what moral values are the current justices' decisions and rulings upon? Is there a collective moral standard regarding rulings being made? This question, he asks, is applicable to everything from race, religion, and sexual orientation.
Yeah, so there is no consensus set of moral values among the justices any more than there is among the American people. So let me state that differently. We all agree on some issues where our views have changed dramatically from the past. I don't think anybody in society today would defend the sort of systematic white-on-black lynchings that existed in the 1890s, when every year, literally, an average of more than 100 black people were lynched, mostly in the South, by whites who went unpunished. I don't think anybody today thinks women should be excluded from legal practice the way that many states did 150 years ago. I don't think anybody today thinks women should be denied the right to vote. So we have certain consensus about, and I don't think anybody today thinks gay people ought to go to jail for engaging in consensual adult same-sex sex. Maybe Roy Moore in Alabama still thinks that, but I don't think that's part of the mainstream of moral values. So we have consensus on some things. We all agree slavery is wrong. We all agree the Nazi Holocaust is wrong. But on today's divisive issues, we don't agree. So why would we expect conservative and liberal justices to agree? They don't agree on race-based affirmative action any more than society does. They don't agree about gay marriage any more than society does. They don't agree about whether the death penalty ought to violate the Constitution any more than society does. They disagree in the same way that society does. The interesting thing is Justice Kennedy is such a swing vote. So Justice Kennedy is with the conservatives if the issue is right to keep and bear arms, if the issue is the right to spend millions of dollars getting yourself elected to office, but Justice Kennedy agrees with the liberals if the issue is executing juveniles or gay marriage or a few other issues like shutting down abortion clinics. So Justice Kennedy's morals essentially are the morals that determine constitutional law today. And if you think that's a weird system, I agree with you. It's kind of crazy, but one individual who happens to be the swing vote on almost every issue is a very, very powerful person, not just today, but perhaps over the course of American history. Justice Kennedy exercises as much power as any single justice. Now, does that make him as powerful as the president? Not by a long shot. The president can start a nuclear war with North Korea tomorrow, and many of us worry that he will. Justice Kennedy can't do that, but Justice Kennedy can determine whether Roe versus Wade is overturned, and Justice Kennedy did determine whether gay marriage is the law of the land. That's a lot of power.
Thanks. Well, I'm going to give David the last question. David's done a great job tonight of kind of keeping us going and all the questions flowing back and forth. And I've really appreciated all of you debating and sharing your opinions with civility and with respect for each other. David's question, our last one for tonight, Mike, is this. Do you think that federal judges should be popularly elected?
It's a great question. I don't think they should be popularly elected. I do think they should be term limited, and I would certainly do away with lifetime tenure. I think mandatory retirement at a certain age is a good idea. I would term limit them, and I would be open to a serious discussion of whether a system of judicial review where judges can decide national policy on issues like abortion, affirmative action, the death penalty, campaign finance reform, gun control, political gerrymandering, recounts in Florida. I'm not sure our system where 9 relatively unaccountable people ought to be making these decisions for a country. I don't like popular election because the way it works is, you know, judges have 2 very different roles in our society. One is they interpret the Constitution. They decide whether abortion is constitutionally protected. The other is they decide individual cases where somebody's life, liberty, and property is at issue. And in that latter capacity, the last thing you want them doing is looking over their shoulder, deciding whether if X gets the death penalty, that's going to cost me re-election 2 years down the road. There is no good argument why a judge adjudicating an individual's life, liberty, or property ought to be thinking about losing their job based on how they adjudicate this case. There is an argument that individuals who are deciding whether the Constitution protects gun rights or abortion rights, that those people ought to be generally representative of the country, and perhaps they ought to be elected. But because judges play both roles, I don't want my judges at the state or federal level to be elected when they're adjudicating individual rights. That seems to me a terrible idea, and the rest of the world thinks it's a terrible idea. It's only the United States where we have 3/4 of our states electing judges, and it has this insidious effect in criminal cases that judges have become so tough on crime and so tough in the administration of the death penalty, leading to over-incarceration. And that's just a crazy system. We should not have that.
Mike, I cannot thank you enough for your time tonight, for your insights, and for your willingness to engage with our audience. Mike, thank you very much for joining us.
Sure, it's my pleasure. I really enjoyed it. Thanks for having me.
And I want to thank all of you for joining us as well, and encourage you to join us for our next Humanities in Class webinar. You can follow along the National Humanities Center on our social media feeds. That's our Facebook page, our Twitter account, which is very active, our Pinterest page. You can also go to our website at any point and take a look at what we're offering both virtually and face-to-face. In a moment, you're going to receive an invitation to do an evaluation. And once you've completed that, you'll receive a certificate for tonight. But I have to say, you know, for me, the real metrics of a night like tonight, a conversation like this, is whether or not you'll both continue to think about it and whether or not you'll discuss this and points made tonight tomorrow. This water cooler test is really important to us at the center, and so whether it's with your colleagues, whether it's with your students, whether you go back and look at our recording and try to chew through some of these issues as well, we would love to hear your continued thoughts. And again, finding us via social media is probably the best way to share that. So please, let this carbonate in you a little bit, and we would love to hear more of your thoughts in the very near future. These recordings are available on our YouTube page. Usually it takes us about 48 hours to get them posted. And again, as participants tonight, you'll have access to the PowerPoint and the associated materials as well. Our next webinar is scheduled for November 30th, which is not until after the Thanksgiving holiday. So I want to wish all of you a good holiday. And that one, unfortunately, is sold out. So take a look at our page, find the next one that you can join us, and we'll look forward to seeing you again here at the National Humanities Center in our webinar series titled Humanities in Class. Thank you. Good night, everyone. Have a great day tomorrow.